Welcome to the Legally Hers podcast. I am Prathiksha Ullal, your host, and this podcast is produced by the Vidhi Center for Legal Policy. Legally Hers is a series of conversations where we explore the law not just as an abstract construct, but as something that shapes women's everyday lives. In today's episode, we turn to the Constitution of India, and through this conversation, we pierce it through a feminist gaze. We uncover what a feminist rendition of the Indian Constitution looks like, and what does it mean for women to reclaim it through collective ownership. We explore how this idea of collective ownership of the Constitution takes shape in protest, memory, and collective expression. We then question the diversity condition in representation. Are numbers enough, or do they fall short of ensuring truly democratic participation for women across different intersectional identities? Along the way, we also unpack the politics of equal political representation in India. This is a conversation about reimagining the Constitution as a feminist commons, which is a space that belongs to everyone. Thank you so much for joining me today, ma'am, for this podcast episode called Legally Hers. Today, we are going to be discussing about the female gaze, the Indian Constitution, and political representation in India. So, I would love to welcome Professor Dr. Kalpana Kannabiran, who is a sociologist and a legal researcher with a keen interest in the areas of sociology of law, historical sociology, social movements, gender studies, disability studies, indigenous Adivasi rights, minority rights, development studies, jurisprudence of colonial constitution and criminal and human rights. Over the past 3 decades, ma'am has co-founded and worked with the Asmita Resource Center for Women and was also a part of the founding faculty of Nalsar University of Law, Hyderabad, where she taught sociology and law, and retired as professor and regional director, Council for Social Development, Hyderabad, and completed a 3-year term as a civil society advisory governor for the Commonwealth Foundation in Dundee. Ma'am, a very warm welcome to you on this podcast. It was really nice that you could take your time out and then talk to us today.
Thank you.
Yes, ma'am. So, to start off, ma'am, could you please give our listeners a glimpse of your journey as a lawyer and an academician?
Thank you very much, Pratiksha, for this invitation. And I'm glad we finally found the time to do this together. What has my journey been like? Actually, my journey hasn't been that of a lawyer. I, of course, have practicing and teaching degrees in law. But I've been primarily a sociologist. I've been a feminist sociologist. I was a feminist long before I became a sociologist. And so a lot of my work has been in the area of women's rights to begin with. My initial forays, even into sociology, were in the sociology of women's studies. For my MPhil and for my doctoral dissertations, it was the sociology of women's studies. For my doctoral dissertation, also historical sociology. And in the course of being a feminist activist and being a feminist student in protest movements against violence against women, particularly domestic violence and custodial rape. These were the two major issues in the late 1970s and early 1980s. An engagement with law was mandatory because you were looking at women who had been injured, harmed, hurt, maimed, killed, and you were following cases, you were asking for justice, so you had to know what justice meant, you had to know what it was tied to, which were the institutions, how could it possibly be articulated within the realms of what was called law. So then you had to understand law. So my journey into law, one part of my journey into law was through feminist activism. And I was part of feminist organizing since my 18th year as an undergrad student in Hyderabad. So that's basically, I mean, if I were to talk about how I came to this particular constellation of concerns, and you will find that whole range in the work that I do in terms of human rights, in terms of minority rights, in terms of women's rights. It's not any single silo. I mean, intersectionality is a term that came into use much, much, much later. But it also tends to get quite opaque. But when you're actually looking at incidents of violence, or you're uh, seeing victim survivors, I have seen Ramiza B from close quarters uh, over several months, when she was testifying before the Commission of Inquiry that inquired into the killing of her husband in custody and her own custodial rape. So you're seeing these people in front of you and you're seeing them talk. And so that then stays with you. With law itself, my engagement started at an academic level. It started with my doctoral dissertation, where I looked at Devadasi reform and looked at the ways in which one part of what I looked at, I mean, it had many parts. One part of what I looked at had to do with judicial understandings of Devadasi life worlds, of property inheritance. So there was one side property inheritance, on the other side, there was the fact that they were being criminalized for adoption and sale of minor for purposes of prostitution under the IPC. And so that, in fact, my doctoral dissertation was what got me kind of, uh, you know, get into the nuts and bolts of how the law uh, that we might know in the abstract operates in the concrete, in its concrete particulars. Uh, and from there, I think it's been, yeah, one thing or the other, but broadly along that route.
But it's very interesting because the standpoint you have through which you look at law is very interesting, because when we see that you've immersed yourself in these social movements. I was also listening to the friend of court the other day regarding the whole civil liberties movement and how your father spearheaded it and how you were also a part of the whole process. So you could see that your view against the state and the larger concepts that we talk to them in abstract. So regarding that, I just want to understand, how does your past experiences relate to your present research interests? I would also like to understand what your present research interests are regarding this.
The other part of my journey into law was as a witness, not in the sense that law uses the term witness, but shall we say more like a fly on the wall, because I was 14 when emergency was declared. And from my 14th to my 20th year, or from my 14th to my 18th or 19th year, actually, I had constantly been hearing accounts of custodial torture, of custodial death, of encounter killings, of commissions of inquiry, of recording statements of witnesses. My home was a safe house for witnesses who were testifying before commissions. And so then you began to understand, okay, what is. So in my 14th year, I had to understand uh, why the death penalty is not okay. Because Kishagod and Bhumia, two Naxalite prisoners, were executed on my 14th birthday in 1975. And so I needed to understand why my parents were constantly petitioning, my father especially constantly petitioning for their mercy, for their release, for the commutation of their death sentence. So then I had to understand these terms. I had to understand what commutation meant, how it was different from a mercy petition, what was unjust about hanging people who had been convicted of a crime. Why was the court prevaricating on it? So the court wasn't certain either. So they just kept deferring the date of execution. And as a 14-year-old, I actually had to make sense of what that constant indecision by the court was. Why one court, like the AP High Court, was willing to defer it, but the Supreme Court, under the respected Justice Krishna Iyer, turned it down. Yeah. And then they were finally executed. So there was no way that I could understand any of the discussions around the death penalty without first understanding what the law was. So, in a sense, it was like a rude awakening to violence of different kinds. Yeah. And all people who are supposed to be custodians of safety, husbands, the police, the state, these are all, archetypal custodians of safety. So, to make sense of that, then you need to uh, uh, develop a sensibility for justice that then will guide you into an understanding of law. It's like it's an enduring trauma of a witness who is not one. So you never ever forget it. And these were cases that happened almost 50 years ago. Yeah, so we're talking about 78, 77, 78. But it actually doesn't leave you. So you, wherever you go, whatever you do, you carry the echoes of that experience forward with you. And I basically think that that really has been my guiding force long before I began to engage quite centrally with law.
This journey has been extremely fascinating because you stand at this unique precipice of the past years and the coming present. So I would like to say this because it's very important for us to go back to the constitution and sort of engage with it. So looking at it, like I want to have, like in this conversation, I want to have a feminist engagement with the constitution, which I feel is not studied as much. So, drawing from your years of looking at the constitution and the state actors and the violence that you talk about, women's bodies has been a site of such violence. And I want to understand how it interacts with the constitution and what the values that were. So, to bring us back to the constitution, I want to pierce it through something I would like to call the female gaze, which is nothing but the female standpoint through which we need to see where the constitution is faring for the women of India and what it promised as a new social contract during those years. So this, I would like to say that we need to direct our gaze to the constitution, as this is the highest normative order in India, as we say the grand norm. So to look at it, if we were to pierce the constitution of India with a female gaze, ma'am, what do you think ought to be changed or reframed in the light of this new female perspective that we're talking about?
I mean, I think the idea of the female gaze is something that we really need to engage with. Also, because uh, I'm not sure where the female gaze begins and where it ends. Because it's all on a continuum, and everything about lives is gendered.
Yes.
and it's gendered across the spectrum. So it's not gendered in binary terms. Yeah. So there is the female gaze, there is the transgender gaze, there is the non-binary gaze, and there is the male gaze. I mean, let's not forget that the male gaze is also gendered. Yeah. So how does how do we actually understand? And that's actually been that's been the challenge for me to develop an understanding of the Constitution that is not hampered by the essentializing of embodiments, but that opens itself out to speech as embodied. So, who is speaking? What are they saying? Why are they saying what they're saying? And how is their speech rooted in the reality of their body? And their body is located in a particular life world. You know, I've actually been over the past several months been rereading Saila Ben Habib's work on dignity, and she, actually talks uh, very, very evocatively about how we recenter the idea of cosmopolitanism and how we recenter the idea of democratic iterations as emanating not from sources of power, but from assemblages of resistance. Yeah, and thus redefining power from a very different location and standpoint. And I think that the idea is, in response to your question, I think the idea is to be conscious that the gaze is always embodied and situated, and that in understanding the Constitution, we don't err in fixing the gaze at one, in a static mode at one point alone, but we explore it to see what are the possibilities that particular locations offer us for interpretations that we believe would kind of strengthen the spirit of the Constitution, which means that we do need to understand what the spirit of the Constitution is. We do need then to articulate what and whether there are limits to constitutional morality, which can't then be, a bounded space, but a space that allows for interpretations to be constantly nuanced and enriched. Yeah. It also means that the gaze is not bound by boundaries, because we've seen the danger of fixing boundaries in the case of the Citizenship Amendment Act. And there you have it. I mean, you have the elder women of Shaheen Bagh telling you what the female gaze is in real terms, yeah, as lived out in a particular context of a particular law in a particular locale. Yeah. So, I think you will have many iterations of that in many locations. In Manipur, for instance, you will have a totally different opening out of what the Constitution should do. In Ladakh, where we are confronting the travesty of Sonam Wangchuk being jailed and removed from Ladakh, we are looking at yet other iterations of the Constitution uh, is the demand for Schedule 6, uh, which is a constitutional demand, a feminist demand, or no? It is. Yeah. So I think the idea is to develop a feminist sensibility that is focused on dignity and justice, uh, and constitutional deliberation, uh, but not entirely focused on women. It must be focused on women, and it must, give voice to all uh, shades of vulnerability that one finds in women's lives historically, while also recognizing that there are so many intersecting vulnerabilities of gender and of social location. Because ultimately, what I have uh, learned and discovered, and it is a constant process of discovery, discovered about feminism is really that uh, you know it knows no boundaries. So if you're asking for justice, you ask for justice, and if you are asking for solidarity, uh, then you have to be able to use that philosophical, uh, the philosophical premises of justice that you use to understand the Constitution will have to be the philosophical premises that you use for justice anywhere. Yeah. And I've been increasingly saying in several of my conversations since October 2023 that, in fact, Gaza and Palestine have uh, radically altered our lens on how we understand languages of justice. And that is core. The core of it is a feminist sensibility.
Right. When we are actually talking about this interesting term that you use, feminist sensibility, that brings us very close, draws us very close to what we call the female gaze. So to understand that, how do you think, what do you think constitutes a feminist reading of the Indian Constitution beyond the contours of equality, which you have stated to mean dignity? Dignity is at the core. You say in many of your works, which is quite interesting. So, why do you think? What do you think is the constitution for women beyond equality, and why do you think we need to have a feminist engagement with our constitution?
Um, it's actually the Constitution, not so much beyond equality, but beyond non-discrimination. And I think one of the primary arguments I've made is that we need to make a distinction between equality and non-discrimination, between 14 and 15, and not treat 15 as a subset of 14. So it is about looking at non-discrimination, because I see and this is an argument actually that I developed in the first instance through my work with women,
Right.
and subsequently kind of opened it out to other um, other locations as well. But to understand non-discrimination uh, as inseparable from an understanding of liberty. Huh? Because what did we see with women? That you are underrepresented, continue to be, uh, even in the latest round of elevations in the higher judiciary. It needed a woman judge to dissent. There's your female gaze and your gender for you. And I mean, she is soldiering on bravely, as the so, but she also dissented with demonetization. So the female gaze has many, many lives and many, many points. So on menstrual justice, on demonetization, on elevation of women in the judiciary, I mean, you name it. And it's all female gaze. Why have we not had any male judges speaking about menstrual justice? Why were women penalized because they sought leave or time out during pregnancy or menstruation? And why isn't there a consciousness of menstrual justice among the men in the judiciary? That's a question we need to ask. Uh, so that at the very least, what a female gaze will do within courts is that it will ensure that women at least have a chance. Now we have one person, assiduously expressing the right to speak. Yeah. But at least if we had more, you might have more people talking about the right to act or to act in favor of equity. We're not talking about act in favor of women, act in favor of equity. So the female gaze then has some very immediate, uh, stark examples that or illustrations that kind of hit you in the face and make you realize that uh, if only there were more women, it would make a difference. But even that is having more women is a necessary condition, but it's not an adequate condition. So you do need women who, we've had women who were extremely carcerally oriented and extremely fixed on partisan punitive jurisprudence while they were sitting in court. So it doesn't really help only to have women, but that doesn't mean that men are better than women. You need to have a necessary number of women in, but that is not a sufficient condition. It's a necessary condition, but it is not a sufficient condition. And there are very direct uh, matters on which I feel not a female gaze, but a feminist gaze would make a real big difference. And I think the two are very important. The distinction between the two are very important. Is the question we need to ask is this, not is a female gaze feminist, but is this female gaze feminist? It has to be particularized. There's no room here for universalizing or generalizing observations. So is this gaze feminist? Is this gaze not? Both are female, which is feminist, which is not, for what reasons? And therefore, what are the sufficient conditions that can qualify a gaze as feminist? So, in what kinds of cases, what kinds of decisions will you take? But having asked for justice for women, can you then say that this will only be limited to women? Will that be feminist? Yeah. So I think not so. But that's my point of view, because I just can't. I mean, we are talking about the continuum, from the human to the non-human, and you can't just suddenly draw a line and say, okay, for these people this is justice, but we are not really concerned about the others. We have to track domination. We have to track hegemony. We have to track the workings of power. We have to track the way impunity operates. Having women, for instance, one of your questions was also about political representation, but having women in positions of decision making doesn't really make a difference. You saw what happened to Dr. Ali Mahmoodabad of Ashoka. You had a woman there as a mayor or head of a local body. So this again goes back to my earlier point about we need to ask not if this is a female gaze, but we need to ask if this is a feminist gaze, and what are the constituents of a feminist gaze. And tied to that intersection of non-discrimination and liberty is the question of dignity. What are the constituents of dignity? Dignity can't be eroded. I am. And because I am, I have an inherent dignity, which nobody can deny me. But how do you act in ways that recognize my inherent dignity? Yeah. So I think that and what non-discrimination and the loss of liberty, whether through rape or through domestic violence or through families holding daughters in custody or through forced marriage, um, or through custodial violence, whatever forms of violence, even through sexual harassment on streets and institutions. What you are witnessing is an interlocking of discrimination with the loss of liberty. These are all forms of custody through which you exercise power and which have the guarantee of impunity. So, how do you begin to dismantle that? And I believe that for me, feminism has actually taught me ways uh, of being with people, of a deep empathy uh, and a responsibility to understand. Because we are not always familiar with the situations we confront, that we have a responsibility to familiarize ourselves.
Exactly. So, very rightly framed by you that we need to understand whether it's not about the female gaze, but it's to see whether the female gaze is feminist enough or not. Because I feel that's a very interesting way to put it. And coming to a very similar part of your work, which is based on the concept of Indian Constitution as commons, it is actually framed by you as a radical act of reclaiming the interpretation of the Constitution by the civil society. Now, what would a feminist reclamation or reinterpretation of the Indian Constitution in relation to your theory look like?
In fact, the idea of the Constitution as a commons was an idea that after just going round and round to say how do we sidestep statist and mainstream judicial uh, declamations on the Constitution. How do we actually open this out to a collective ownership, a collective usufruct? Yeah. And we saw that collective usufruct in action during the anti-CAA protests, where the preamble was the anthem of resistance. Yeah. And it was both. It was the preamble and it was the assertion particularly by women uh, and very ordinary working class, lower middle class women for the most part, that the claim to citizenship is not based on the state's uh, diktat to draw a line or inscribe a border or a boundary, nor even of courts to deport and, you know, turn the other way. But it is based on a deep attachment to place. So, I don't have the papers, but I can name 7 generations that have lived in this land. Can you do it? And I don't have the papers. I don't even have my birth certificate. I don't know. I was born at home. There's no proof I can produce. There's no document. My legacy is my emotional attachment to this land. My legacy is the labor that I have provided to make this land what it is. Yeah. And you can see this idea of asserting a legacy in very different spaces. So you also see this assertion of a legacy to a land in the case of forest dwelling communities that are facing eviction. And there as well, I mean, you had, of course, the Chipko movement, you had large numbers of women, in the Narbada struggle. You had a large number of women in the fish workers' struggles. That in every struggle, at every point, you have had women have joined men in equal numbers, if not more. And the the articulations that those movements brought was to question the state's commitment to the letter and spirit of the Constitution and to assert their legacy in terms outside of bureaucratic inscription and framing. So no, kagaz nahi dikhayenge. So we don't want to show you a paper. We are not interested in showing you a paper. I don't care what this piece of paper says about whether I'm a citizen of India or Pakistan. This was a case that I looked at quite closely of the 1950s. But I belong to Madras and I will live here. With or without papers, I belong here. I'm a Tamil woman. Not I'm a Muslim woman. I'm a Tamil woman and I belong to Madras. So I think that assertion of a deep attachment to place, of the right to stay, and of the right to move around within the territories that you traverse in the course of providing labor, is something that just cannot be taken away from you. And that is a much more poignant tale that women tell you, because it's women who traditionally and culturally, uh, in several communities, have had to uproot themselves and leave home. Yeah, and so the language through which they speak of citizenship, or the language through which they speak of belonging, is very different. And it's from that I said, if we must capture, or if we must not capture is the wrong word, if we must grasp the the depth of what women are trying to convey to us through struggles that seem very, very ordinary and everyday, through speech that seems very ordinary and everyday. If we are to grapple with the depth of philosophical meaning in their speech, we have to move beyond thinking of the Constitution as the preserve of hyperliterate elite classes. We have to move the Constitution into its everyday locale where there is a collective citizenship, where there is a collective ownership, not in terms of documentary title, which is a very male, language of ownership. They even own women in that way. Yeah. So it's not in that in the sense in which a dominant male understanding of ownership would proceed, but in terms of a collective usufruct. Yeah, you will see, for instance, shades of that also in different legislations. If you look at the Protection of Women from Domestic Violence Act, the fact that a woman cannot be evicted from her marital home merely because she doesn't have title to the property. That she has a right to usufruct. She has a right to residence. The place belongs to her irrespective of documentary title, and so she cannot be removed. So if you look closely, what I then realized what I was trying to articulate, if I look closely enough at different sets of legislations, there may not be too many. I immediately kind of the parallel with the Domestic Violence Act struck me. But if you look carefully enough, you will probably find that the uh, echoes or the suggestions of the Constitution as a commons that belongs equally to all, no matter which party is in power or who comes or who goes.
Come to the idea now, ma'am, about representation, like political representation for women, which has been an ongoing conversation as since India got its independence, and it has been an ongoing conversation till now. Um, Ma'am, when we look at political reservation for women, and the idea is it always stops at diversity, that we need more women. Like, okay, we need more women, and it stops at that. Like any question as to why do we need more women, only stops at diversity. So I just wanted to explore one of the most undiscussed arguments when we talk about reserving representation is that the difference in perspectives, the difference in lived experiences that women bring to the lawmaking process. So it is very important for us to center women's experiences into seemingly neutral laws. When you also spoke about the language that women use to express themselves is quite different from the male language that we know. When we look at laws, to prevent discriminatory impacts of this language on women, which is quite alien to how women express themselves, ma'am, do you think centering women's experiences in laws would break us free from this innate unimplementability of laws that you often talk about? When laws are not tailored with a feminist gaze, how can we solve issues that plague women?
The problem with laws, particularly in terms of how they're drafted, have to do with the exclusionary language that is used in drafting. Yeah, so you normalize the male, you normalize the upper caste male, and you normalize heterosexuality in the very drafting, in the very way in which laws are drafted. Yeah, and that problem certainly manifests itself in a whole range of different legislations and different provisions within legislations. For instance, if you look at the Indian Penal Code, different sections that look at the human body and the gendering of the human body, you will find that although there has gradually been development, and now actually a rollback, but a development in the way in which particularly sexual crimes against women were described in law. The unimplementability of it came from the very framing of rape, for instance. Yeah.
It's it.
And the everything, the way in which evidence was gathered, the way in which evidence was presented, the way in which cross examinations took place, the whole discussion in courts on corroboration. The offer. I mean, I was at a in the mid 2000s. I was part of a larger effort to initiate conversations with district judges, from the chief district and sessions judge down to the magistrates. Uh, and I actually came across several cases where uh, magistrates and other judges in the district judiciary had a fairly good sensibility, had a fairly good understanding of the criminal procedure code. But the senior most district and sessions judge in one of the meetings said that marital offer of marriage is a mitigating circumstance in cases of rape. So if there is a rape victim and the accused offers to marry, he should be let out under the Probation of Offenders Act and allowed to marry the woman. And we said, what reading of which law gives you this interpretation?
Correct.
At what point in a criminal trial are mitigating circumstances presented? What are the limitations of the Probation of Offenders Act? And which part of criminal jurisprudence allows you to suggest, as a judge, at that point he was a serving judge, allows you to suggest as a judge that offer of marriage by a rapist is a mitigating circumstance in conviction. And so there was that there were, but I must say, this person was the senior most, so most of the other judges, given the fact that the judiciary is the most hierarchical institution that we have in the country today, absolutely the most. Even the political sphere is not that hierarchical. And we have such a lovely study by Chitrakshi Jain and Prashant Reddy on the district judiciary. And I was at one of their presentations in Hyderabad, and I said, I'm so glad somebody is talking about this. But so the others wouldn't actually say that they thought it was wrong. At tea time, they came to us and said, no, that's wrong interpretation, that's wrong interpretation. And we were doing these workshops with Justice D.K. Basu as the head of our team. And so we just kind of called him aside and said, you better tackle this. And so he and Mr. Shanti Shekhar Mukherjee, who was a very senior, an elderly retired sessions judge from West Bengal, who then actually went through the criminal procedure code and relevant sections bit by bit by bit to say, okay, is this the interpretation? So the argument that we came up with then was that if you followed the criminal procedure code, letter and spirit, human rights would be protected. There are inbuilt protections. The problem is that you don't, and that an extremely misogynist, patriarchal mindset interferes with your interpretation of the procedure code. Yeah? Not saying that there was no problem with the definition of rape in the IPC. But even with that retrograde definition of rape, it was possible to rule justly using the procedure outlined in the CRPC.
And the female gaze.
But the question that then came up at that time for me was that uh, is it enough to have a law that is drafted from a feminist perspective? Because if you have a patriarchal mindset, that it will rip through any law that you make.
Right. Correct.
Because the modus operandi and the uh, ultimate goal of the patriarchal mindset is to entrench the patriarchal mindset. It is its own logic and its own culmination. Yeah. So we do need to have more sensitive laws where, that are not exclusionary of entire classes of people, whether women or Dalits or Adivasis or minorities or Muslims. You do need to have laws that are not exclusionary. But besides having laws that are not exclusionary, you do also need to have officers, not just in the judiciary, but your investigating officers, in the police, your apprehending officers. I mean, you have to have a whole lineup that is willing to be divested of the privilege of being male.
Right.
In order for this to, in order for a feminist um, drafting effort to reach fruition.
Yeah.
Yeah. So because you have the Domestic Violence Prevention Act, I know there was a huge feminist effort in drafting that legislation, and it is a great legislation. But look at the conditions on dowry that the Supreme Court, the guidelines for offenses of dowry-related offenses that the Supreme Court has issued. And so, you can just defeat any good law if you don't, if so the having the good law doesn't really necessarily mean that you will have feminist justice at the end of it. And with the Constitution, I think it's a very broad framework. There are no specifics in it. And within that broad framework, interpretively, feminist concerns are well accommodated, can be well accommodated. But if I go on the basis of my own work on jurisprudence in relation to women's employment and education, you will see how the highest courts, because that entire work, Tools of Justice, was based on reported judgments of the High Court and Supreme Court. And you will see how, the entire interpretation of enabling constitutional protections was totally unraveled interpretively by courts. And so I think that the problem really lies there. In politics, yeah, we need to have women in. But needing to have women in could mean having Sadhvi Ritambara, having Smriti Irani, having Sonia Gandhi, having Dakshayani Velayudan, having Begum Manias Kidwai, any of them. But what is the consciousness? So we need to have the numbers. On that, I have absolutely no ambiguity. The numbers are not a choice. The numbers are mandatory. You must have equity in representation. But again, like I said earlier, that's a necessary condition. Is it a sufficient condition? No. Because once you have equity in representation, the challenge still remains about what are the ideological, the political basis on which decisions will get taken. Yeah, and for that, actually, you need a feminist revolution, an armed revolution, a no, feminist revolution.
And what do you think a feminist revolution would look like today, if it were to happen?
Oh dear, that should be another interview.
Exactly. Like, I really like your framing when you say having feminist laws is not enough. We need feminist actors in every way, where we interpret laws in a feminist way, where we make laws in a feminist way. That's very interesting. That breaks down the argument of numbers again, like saying that having sufficient number of women is important. It's definitely important. But
Not important, mandatory. It's mandatory.
correct. Mandatory. And the fact that the feminist gaze is also very important for laws to work, as you also gave many examples. Uh, Ma'am, to understand this debate, like right now, when the Women's Reservation Bill is now an act, it has been passed after 27 years. Like, we need to understand the politics that went behind it. Ma'am, could you give our listeners a ringside view of the 27 years worth of politics and the most contentious issues that came up during this debate, whether women have to be given reservation or political reservation or not, and what were the politics behind this, and what were the most contentious issues in this debate?
This is actually a very, I mean, it is a very enduring, uh, an enduring in a negative sense debate. And it's not so much about whether women should be given representation or not, but what are the ways in which women should be obstructed? It's the other way. I mean, how do we prevent them? Not how do we give them or how do we let them in, not the terms of letting them in, but the terms of keeping them out. Yeah. And I think in that, parties across the board have succeeded quite a bit. But when I was looking at the older debates, and of course, right through from the Beijing Platform for Action, we are now at Beijing 30 plus. And there's a whole series of meetings going on the action agenda of the Beijing 30 plus, and how do we take the Beijing World Conference on Women's Concerns forward 30 years later, and so on. The debate on women's reservations started then. So we're talking 1995. And immediately after that, the whole effort to table the bill in Parliament, and Geeta Mukherjee's struggles. I mean, that's all history that has been written, that has been discussed. But even at that early, and then there were several world conferences before Beijing, the Vienna Human Rights Conference. After Beijing, successive alternate reports on CEDAW, the Convention on the Elimination of Discrimination Against Women, that pointed to the paucity of women's representation in legislatures and parliaments, although that the numbers issue had been fixed in local bodies. It still remains to be fixed in legislatures and parliaments. So there'd been a lot of effort in mobilizing and capacity building by various women's groups on teaching women to handle authority and power and schooling them into skills of governance and all of that. But even in the first effort in the late 1990s, when the bill was first tabled, there were no women, and I hadn't actually read these debates at that time. More recently, when I was looking at the 106th Amendment Act, I went back to those debates, and what struck me was the directions that women's representation took So, and the way the polarizations actually happened and the way those polarizations were represented outside. Because what I had seen up to that point was only the way the polarizations had gotten represented outside. But if you look closely at the debates, you find that particularly Sharad Yadav and Nitish Kumar, what has happened to him? But these two people, uh, you know, put together a really robust argument on the fact that merely getting women in is not enough. You need, equitable representation means equitable representation across the social ladder. And you need to have that at the inception of the Reservation for Women Act, because if you don't bring it in then, you will never be able to bring it in later. So they said, you don't yet have a law. So when you don't have a law, why don't you enact a law that is representative? So that we are not again having a movement, and there's another polarization saying, why are OBC women or women from underrepresented groups not represented here? Which is, I think, the way in which they argued their position was really very, very striking. And unfortunately, that was just caricatured in the media, and distorted even. And revisiting those arguments was just such a learning for me. And I felt that it was a really sad thing that those debates had not figured in the contemporary debates around the reservation issue. I think the debates in Parliament ought to have been preceded by a public reading of the debates of 96, 97, so that people would know how concerns had been articulated. So again, I mean, like you say, it's in abeyance. What you had then, you have now. You had Sharad Yadav and Nitish Kumar raising this issue then. You had nobody raising it now. And so you have literally the same law enacted, 27 years later, with all the political debates on a graded law. If you're in a graded, the idea of, and in fact, they say this in so many words. If you're in a graded society, the law has to represent the gradations in society. And that is our understanding of equity. Yeah, even from a feminist perspective. So the two people who were speaking the language of feminism in 1996, and I must say, are Sharad Yadav and Nitish Kumar, because they were the only ones who articulated why it was important to have a representative Women's Reservation Act. Whereas for all the other votaries of women's representation, it was just bring the act and we'll do that later. But we've seen from the best revolutions in the world, Cuba, Nicaragua, Telangana, Tebhaga, wherever you see, the argument of revolutionaries, the argument of male leaders of revolutionary movements is always, let's bring the revolution and women's liberation will come later. And women have consistently said, if you don't have women's liberation when the revolution comes, it will never come later, because we will just go back into the kitchen. And that was the same kind of spirit that you find with Yadav and Kumar's articulation, that you need to have representation at the inception. It's not something that will come later. And now you have the law in abeyance. So we have to wait till delimitation, till the next census. God knows when that will happen. So it's a nice placebo, this law. we
Exactly. When we also talk about the mothers, and I've also read some of the Constituent Assembly debates in which the women Constituent Assembly members staunchly said that we do not want reservation. It's we don't want that favor because in the natural course of democracy, we know that it's a very idealistic view that all sections of the society will be adequately represented. So it's there is a role reversal right now, and the tables have turned. In right now we see that it's an imperative that we need to have this uh, reservation bill right now. And ma'am, what do you think about the inclusivity of this bill? I call it a bill because it's not yet been implemented, and we don't know when it would be. So I'm very cautious in calling it an act per se. Ma'am, why do you think it was not extended to women from the OPC and the minority communities? Because I feel they also form a very important part of the electorate of women that we might have to consider.
it has to do with political voice. And I think that in terms of the founding mothers, they were a small section of women who threw their voice out way beyond, uh, way beyond their capacity, and they kind of extended their concerns way beyond. And there was only so much that they could handle, but also in their own individual lives. I think that they had come in through participating in the political process and making their voices heard. Yeah. And so representation was not really a concern. But that doesn't really make a difference, because this is not something new. I mean, since the first general election, 51, when have we had equitable representation for women in the normal course? Never.
It's it.
Yeah, so it's not a new history. This is a very old history, and the idea is that when we are talking about looking at original debates and seeing what were the demands, we also need to historicize the present. And following a constitutional debate also means knowing when to depart from it, not on substantive concerns, but on representational concerns. So, how, for instance, would you work your way around a binary definition of gender when talking about representation in parliament? I mean, that's the question none of us are asking. So for me, it's not only a question of women's reservation. Yeah, because I know that the Jayanti Natarajan committee had recommendations on reservations or representation of transgender communities.
Right.
Yeah, but that doesn't figure. So I mean, I think that concerns relating to gender are varied, but we still remain very stuck, not just in not providing for reservations for OBCs and minorities and other unrepresented groups, but that the uh, the fact is that we are trapped in a binary. So it's almost as if the world of politics in this country is split between men and the women. The men will occupy, the women will be thrown out, and there's nobody else left. But how do the challenge for me, even as I was writing that piece on the 106th Amendment, my challenge was really, how are we going to begin to articulate the question of a gendered representation that is truly representative and not, again, trapped within a binary understanding of gender. Yeah.
Exactly. So, ma'am, again, as we come across these quotes which say that by Martin Luther King Jr., who actually said that a delayed right is a denied right. So, ma'am, what do you think were what for our listeners? What were the conditions? What are the conditions imposed on the implementation of this bill? Have to say act. And do you think these were necessary, or they were just a way to defer the implementation?
To not defer. It's a way to keep women out. I told you. I mean, this is not about including women. It is about finding ways to keep them out. Yeah. So I must say there is a hell of a lot of creativity on the part of men, to keep women out. If only they used it in the service of justice, we would be in another place.
And thinking of another place, ma'am, just to end, and there was a very insightful discussion to say the short story by Begum Ruqayya Singh.
Yeah, Sultana's Reign. That's my favorite.
Yes, exactly. So, where the women, for our listeners, I asked this to all my guests actually, and the answers are very interesting. And, ma'am, so Sultana had her dream. So, ma'am, what is yours for our world?
What is mine for the world? I mean, everything, actually. Dignity in the first instance. The every opportunity and occasion to self-fulfillment and self-expression. And a place in society, in the country, in society, that is free of exploitation and oppression, and a place that is built on principles of self-respect, Swayamaryade, on principles of Maitri, Bandhuta, fraternity, and deep conviviality. Yeah.
Thank you so much for joining us for this, ma'am. This was really very insightful.
Thank you.
Dear listeners, thank you so much for tuning in. In our next episode, we direct our gaze to the Parliament of India, where law and representation converge to bring the female gaze into sharp focus at the heart of the country's highest lawmaking body. We trace the unexpected yet powerful intersections of poetry, politics, and perspective in a deeply engaging conversation with a much loved member of Parliament. Together, we explore what it truly means to connect with constituents and how a politics rooted in empathy might begin to reshape the way India represents its constituents. Join us for our next episode as we step inside Parliament and reimagine what empathetic political expression can look and feel like. Please write back to us regarding any thoughts or insights you might have on how to integrate women's experiences into law study. I've also attached a set of readings and links that shall provide more information on the topics we discussed today. Please write to us should you have any questions or need any more further information. Thank you so much and stay tuned.